trademarks create foundation. They create credibility.
A design mark is anything other than a standard word mark. Think Tiffany blue or brown for UPS, anything that identifies your brand.
You're not going to go and take the Nike swoosh and flip it around and say, oh, that's mine, I stylized it. It really has to be unique and not be confusingly similar to any other brand that's out there.
You could have a logo, but you could also have other visual elements that are involved in your brand that can also be protected.
But Holly, what are we protecting?
So it's pretty simple.
These are all some of these strategic considerations that we talk about with our clients that go beyond just the words. If the USPTO has an objection to that word mark, if someone else files an opposition, you actually have to rebrand. You can't just remove that. Those elements, that process helps you protect your brand.
One more consideration is, what if you created your logo or your design in a third-party app such as Canva? Do you own the rights to that design or that logo that would allow you to file for trademark protection?
We can never give a guarantee, but
join us as we explore trademarks, copyrights, and intellectual property to ensure the protection of your creative asset.
welcome back to Securing Your Brand with SecureMark Legal, the legal podcast where we break down how to protect, grow, and enforce your business's most valuable asset, its brand, your reputation. We're your host. I'm Melissa Jeda.
I'm Holly McFall.
And we're going to discuss when, how, and what you should do to file and protect your design mark. What is a design mark? What are we protecting?
So it's pretty simple. A design mark is anything other than a standard word mark. So as soon as you add even style or font or color to your word mark, it becomes a design mark. So similarly, your logo, any other stylized brand elements or images that define your brand. That can also include color, blue or brown for UPS. It can be taste, smell, anything that identifies your brand that is not a standard word mark.
So anything that recognizes your brand that is not just the letters of the name of your brand. So we could be talking about like that Nike swoosh,
Yes.
the Coca-Cola bottle shape. All of that would be like a design mark. All of that would be able to identify the brand. Sometimes people call it just their logo, but it really is anything that identifies your brand.
That's right, because you could have a logo, but you could also have other visual elements that are involved in your brand that can also be protected, not just the specific logo that you normally use in a logo sense.
So this is something that we do in regards for our clients we file it with the USPTO under the trademark application process, just like we conduct a search for the word marks, just like we conduct the search for the brand. And we make sure that there is no other confusingly similar, because you still can't use someone else's logo or someone else's brand identification marks. It's still protected the same way through the USPTO. Can't make sure that anyone else, you're not going to go and take the Nike swoosh and flip it around and say, oh, that's mine, I stylized it. It really has to be unique, cannot be confusingly similar to any other brand that's out there, just like your trademark.
So your logo, for example, can include your brand name, right? That's a strategic consideration that we make, after we run that comprehensive search, because the search will include any words that are in your logo or your design mark.
So one of those considerations is really like where that name, if you're going to have your name as part of your stylized element, simplification purposes, let's just call it a logo. So if your logo is going to be a duck wearing a bow tie, and you want to put that you are whatever is the name of your company. We got to come up with a company for this podcast, Holly. We got to create something so we can explain it here. We got to create a company here, Holly. We got to, make this simplified and explain this a little bit easier. Let's get creative. Let's design a company here. Okay, we got a duck wearing a bow tie. We are fishing equipment. We are specifically, that fly fishing equipment. We got a duck wearing a bow tie. And so we want to call our company Light Stream Fishing. I don't know. We're going with it. So we want to call our company Light Stream Fishing. We have the element, the duck wearing the bow tie, and then we have the words. Mm-hmm. We advise our clients sometimes that element can stand on its own. That's a unique element of its own, and that duck can become a design mark. It's their logo, it's the design mark. And sometimes you have your logo with the words underneath it. So you have your duck wearing a bow tie, and you have, what did I call our company again?
Light Stream Fishing.
Thank you. So we have the duck wearing the bow tie, and we have light stream fishing underneath it. Sometimes you're going to have the words to the left or to the right of it. If you are not going to always use the words in the same location, you may want to register the design mark without the words, without the brand name associated with the logo. If you are going to always have it, or it becomes an integral part of that logo. So the duck wearing the bow tie is wearing a shirt that says light stream fishing on it. You're going to want to have the word element as part of your design mark element. And it's a stylized part of that element.
Right. So leaving the word out of the registration just gives you more flexibility. Your marketing and website team will probably appreciate that because they can use it in different forms. In some places, putting the word underneath just may not fit into the overall aesthetics of, that web page or that flyer that they're trying to design. So filing it without the words allows you that flexibility to either leave the words out or place the words elsewhere next to the duck or above the duck or whatever.
We're going with the duck theme. So we've got this duck and we've got a bow tie, and the duck is always wearing a blue bow tie. So we have this mallard duck, green beak, green head, yellow beak, however a mallard duck looks like. I'm not a duck expert. And maybe sometimes he's holding a fishing pole and maybe sometimes he's not holding a fishing pole. And, are we going to, those are considerations of which of that brand logo are we going to file for registration? Are we filing for it in color or without color? Are we filing it, with the fishing pole, without the fishing pole? Are we filing both? I mean, these are all some of these strategic considerations that we talk about with our clients that go beyond just the words.
And that can be a timing consideration sometimes. If you have a brand new company starting out and you say, should I file for my logo or should I file for the word mark? If you're unsure what the ultimate form of that logo or that design exactly of the duck, for example, is going to be down the line, perhaps waiting to file for that design mark would be the best strategy. It takes generally about 8 to 12 months to go all the way through the trademark process, whether it's a word mark or a design mark. So that's quite a bit of time if you're still developing your brand. Usually the word mark, the name of your business, doesn't change during that time. Usually once you settle on a name, you stick with that name. But because logos and designs can vary somewhat, especially in the beginning development of your business, a lot of times we recommend starting with the word mark and then later on following it up with an application for the logo once all of those specific design elements are kind of more set in stone. And then it makes it easier to make that decision of color versus black and white. Hopefully by then you have a better idea of whether you plan to stick with this specific version of the duck, for example, long term, or if you want the flexibility to change the color from time to time.
You bring up a good point there, though, about filing the word mark first. If the USPTO has an objection to that word mark, if someone else files an opposition to that word mark, and you actually have to rebrand, if you had filed both applications with the wording in that brand, and you had to go through and rebrand, something changed with your brand name, and you would include those word elements in your design mark application, you can't just remove that, file for the logo. That's a material change. So that's another consideration in whether or not we're going to include the words in our filing for a design mark.
It's not always just the logo that may change until you have the registration on your word mark. You never know, what might come out in the USPTO's search, or if a common law usage may pop up. That having that flexibility to change the word but still keep your logo, the meat of the design of your logo, that could be a good thing as well sometimes.
Especially for a new brand. I mean, if you're fully established and you've been doing this for a while, you're set. You've got a full media plan and you're set to go forward. Maybe it's filing both at the same time, the design mark and the word mark at the same time. If we know that both are going to clear, we can never give a guarantee, but if, there's less risk going forward, maybe filing both at the same time. We talked about the color versus black and white. So Let's explain that a little bit. Let's break this down, because a lot of people have specific colors that they file. They have their brand colors that their marketing company is using, their marketing team is using, and their logo is in this color. As we know, because we've gone through a couple of colors now, we know that, sometimes the color doesn't show up right in a marketing material, or we want to be able, use it to go with a theme that we're doing for whatever presentation or exhibit that event that we're attending. This is a consideration as to like whether you're going to file and claim those colors. Are those your unique colors that you're always going to use? Or are you going to take your logo and put it in black and white? So that way you're only protecting the elements of that logo.
Right. And then remember, going back to that comprehensive search that we do, if there is a consideration that you may want to file in color, it's also going to depend on the results of that search. We have to make sure that there aren't any other companies out there already using that color in your industry as their main color in that way, because that could create a conflict there where you may not be able to obtain trademark registration specifically for that color.
It also gives you that greater flexibility. Black and white, unless you are having your own custom color, black and white, registration gives you some flexibility. But colors do create a strong brand. You mentioned Tiffany blue, UPS brown, T-Mobile pink. All of those are like recognizable for their product just based on the color. You see a box in blue, you know what it is. Coca-Cola red. I mean, those are all recognizable. You see it, Coca-Cola in a whole vending machine. You see the Coke can, that color without it even facing you. You know that's a can of Coca-Cola.
The blue for Pepsi versus the red for Coca-Cola.
Yeah, we could do a whole podcast on the Pepsi versus Coca-Cola battles and back and forth and what they've done for their trademark and brand protection.
Yeah, it's a fun one for sure.
But you also lose if you do it in color and then you go forward and you're filing it, even though you have that recognition and you only protect that color, you may end up losing it if your trademark evolves. Penguin has evolved so many times over the years, and they have multiple trademark applications and registrations for their design and their colors. That's one of the considerations, that if you are doing a color and you do love this color, we know our clients, they love their name and they love their colors. You run the risk if you evolve and you don't file another design mark with the new color, you could lose that protection also. These are all kind of like strategy things that we discuss as we're going through and filing a trademark. How often are you going to file that trademark? When you evolve your brand in a few years, 3-5 years is kind of the typical logo stance, and then 3-5 years is kind of the typical logo lifetime we've seen. Even though companies do change their logos evolve, stylized elements evolved. Even though logos do evolve and they change every few years, stylized elements of that logo may evolve. Maybe your font evolves and things as you go through it. You realize that you want to do a design mark for your brand name for a stylized font. Going back to our duck wearing a bow tie, holding a fishing pole, light stream fishing. Maybe they make it so it's watered, or it's, the words are more stylized in that regard. You can file a trademark for that stylized font also, and it shouldn't prevent you from filing trademarks. As you create brands and you identify this brand, you stylize this brand, those elements, that process helps you protect your brand and your brand recognition. Even if you don't hold it for 50 years in regards and that, it is something that is going to protect your brand as you build. And we know that trademarks create that foundation. They allow your brand to build, have recognition, have credibility. And that does, as you go through your process, change. Your brand name may not change, but your stylized elements may change throughout the years as you go through it. And it's a good thing to do kind of a yearly or bi-yearly kind of evaluation of where you're at with your stylized elements for your brand.
Yeah, so generally I would say that most of our clients, we recommend just doing black and white, starting out with a black and white logo or design mark, because you can use any color that you want then. You're protected for any color variations in that exact design, limited to any particular one. You can change it whenever you want, from situation to situation, different holidays, pink for breast cancer you can use. It gives the most flexibility. And then maybe later on down the line, if you do settle on a color and become recognizable like Tiffany blue, we can always file another application in the future claiming color, and then you would own it both ways.
That's a good point, to own it both ways. It's a good consideration. So we recommend filing the word mark first. When you have your design ready and set, filing your design mark, sometimes with or without your words, depending upon how your logo is going to set up. Whether that logo for your brand name is stylized, that can be a separate design mark application and go through the process. And we know that sometimes one application gets filed, we'll file the word mark first while they're creating their logo, and then we'll go ahead and file the logo, the design mark application, and they kind of get pulled together, get assigned to the same examiner when something gets assigned. So hopefully it will shorten the process if we delay filing the design mark while you finish up the logo. So that way you're not delaying filing your word mark to get those all pulled together. It's one of the considerations. The USPTO, like we said, is going to do a search of those design elements, make sure they are unique and not confusingly similar to someone else's. We know that you are not going to get a logo if you are using you're not going to get a logo for your brand name as a stylized font. If you're using a common font, it does have to be stylized and your font. No using Coca-Cola to write your name. That doesn't work that way. Or even Star Wars. People recognize the Star Wars logo font also. You're not going to get a design mark on your brand name for that. The USPTO will go through that. And then you can also set up third-party watches, so that way you're watching your design marks and going through and making sure that your design marks are not being infringed upon, just like you can for your word mark elements.
So one more consideration is, what if you created your logo or your design in a third-party app such as Canva? Do you own the rights to that design or that logo that would allow you to file for trademark protection? So that is going to depend on the terms and conditions for that app or program that you're using. They vary widely from program to program, so it actually is important to read the fine print in this situation to make sure that company, that app, has not retained the rights to trademark protection. It could say in there specifically that you are not allowed to file for trademark protection. So keeping that in mind before you put in all the work to design your logo is important. And then also, if you used contract person, through Fiverr or something like that, you hired somebody to create your design, making sure that you understand the copyright law there. The person that creates the image owns the rights to the image unless there's an agreement otherwise. So you have to make sure that you get it in writing with that person that anything they create belongs to you and that you have trademark rights to that image.
So the owner of the trademark has to actually own that image, so that way they can go ahead and file the trademark application, not only through the third-party apps, creators that you may hire, marketing companies. One of the considerations is, if you're using a marketing company, you want to make sure that you own the rights to file the trademark and the copyright protection. And then we should probably mention AI because it is going to affect everything. So one of the considerations is going to be, how was that trademark design? How was that stylized element created? This has been a lot, Holly. We have talked about everything from the difference, when to file, how to file, considerations of words and black and white. And we've even kind of started talking about what our next episode is going to be about. We're going to break down and kind of go through how AI is affecting copyright law, and even how AI is going to start affecting trademark law. I am Melissa Jeda.
And I'm Holly McFall.
And this has been Securing Your Brand with SecureMark Legal. Look forward to seeing you next time.
Thanks for joining us.
Join us as we explore trademarks, copyrights, and intellectual property to ensure the protection of your creative assets. While we are lawyers, we are not your lawyers. So nothing contained in this podcast creates an attorney-client relationship or constitutes legal advice. The views and opinions of guests on our show are not necessarily those of SecureMark Legal and are provided for informational and educational purposes only. This presentation is protected by U.S. and international copyright laws. Reproduction and distribution of the presentation in whole or in part without written permission of SecureMark Legal is prohibited.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.